So what's a notice of proposed action in California probate real estate, and why should you know about it and be careful with it? So one of my sayings in real estate is nothing's a problem until it's a problem. And I get told by real estate agents all the time, well, probate listing with full authority is just like any other listing. Well, it is until it's not. It's true that for most probate cases where the administrative executor has full authority, the most substantial difference in the whole process is the different forms. So we do a probate purchase addendum and a probate listing addendum. And as long as everything goes smoothly, that's about the extent of what's required. There is one form. So if you go with limited authority, that means a court approval of the sale is required, as well as a court hearing to confirm the sale with a possible overbid. That's more complicated. The more simple approach, full authority, for the most part, means it's a normal transaction. There's one form, but that form could possibly trip you up if you don't know what you're doing. So let's get into that. That's a notice of proposed action. The biggest mistake I see in agents in their MLS is they'll say that court confirmation not required. That's not the proper verbiage, because you don't really know if it's not required. What do I mean by that? Let's take a look at the residential listing addendum. The probate listing addendum and advisory. That's the addendum to the residential listing agreement. So in this form, you basically are saying that the listing agreement is addendum as followed. If you look here closely, number 3, this is a sample form. I'd rather bring up a customer's form. Court confirmation of sale, there's blank. A box is required, so that's called limit authority, where it has to go to court sale. Or notice the verbiage, may be required. You might say, well, no, it's not required. Why is it may be required? Full authority. Doesn't make sense. Here's the reason why. Because when you have a full authority case, you still have to file what's called a notice of proposed action. And if you do that, what happens is the attorney or the paralegal or the executive administrator, whoever's filling out the forms, fills out a form that looks like this. It's a form, let's see here. Can you guys see this easily enough? Let me blow up a little bit. There we go. It's a form DE 165, notice of proposed action. And this form gets filled out, and what happens is that the personal representative puts their name, and they say they have full authority if they do, if limited. And then this is the proposed action. We're going to sell 123 Main Street for $850,000. Now, I've seen some attorneys put very limited information, just the sell price, who the buyer is, the date they intend to close. I've seen others write a lot of detail. Why would you do this? This form then gets sent to anybody who's required to get notice on the case. Any other heirs, any creditors who filed the proper form and such, any objectors, anybody who's arguing. And when they get this form, if they object, they put their objection here, right? Or if they consent and approve, they consent here. And so the normal course of business is these get sent out to any other parties. And if they consent, you're good to go. You've got their written consent. There's a law that says they have to have 15 days notice. So this form, they have to receive it and 15 days to act. But if they respond back and consent, then you're good to go for that individual investor in most cases. There's some disagreement legally as far as how that works, but generally speaking, title companies will allow you to close if all the parties required have written consent. But what if somebody objects? And that's the key. So you can have several heirs, and they can all get along. They're brothers, sisters, and then all of a sudden they find out, what? You're selling it for $480? I thought I was going to sell it for $520. What? You're selling it? You're buying it yourself? That requires court confirmation. What? You're selling it to your friend? You're selling it to this investor? You're selling it to this shady person? Sometimes people get in the ears of the heirs, and while everything's going smoothly, as soon as they get notice of a sale, they check the box and object. And that's why now on the purchase form, on the listing form, and let me go back and get that. That's why you see this particular verbiage that says may be required, because it wasn't required. You didn't think it was required. You sent out the notice of proposed action. Now one of the heirs complains. What happens? Well, the court has to decide, either A, give both parties their day in court, let them talk about it, or B, they resolve it amongst themselves, or C, The court has to decide, and the court will file dates, and there'll be hearings and evidence if required and such, and go on and on and on. So that's why you want to cover yourself, and when you put it in the multiple listing service, don't say court confirmation not required via full authority. Put may be required. That's the form that's on the listing addendum. That's the truth, that it may be required. And the more professional real estate agents put a sales subject to notice of proposed action. Now, if the only heir is your client, there's no creditors, there's no other parties we noticed, then you know that your customer is going to get what they want. This is particularly important, though, that you notice everybody if there are multiple parties, because today's sibling, along with a program, might change their mind down the road. So I'm Bill Gross. I'm the LAProbate expert. I'm not giving legal advice, but I'm trying to help you through the business process, whether you're an investor, a realtor, or family going through probate. If I can help you, you can call, text, or email me at the number down below. And as always, make today your best day ever. Thank you so much.